Intellectual property is key to the value of any company, but it's a fiddly and complex area of law. In this interview, I'm going to speak to Luke Kempton, partner on an intellectual property team, about commercial agreements and the role of intellectual property in them, so that you can be sure that you've dealt with it in the right way. Luke, in a commercial agreement, how do you go about managing intellectual property?
I think you need to think about ownership of intellectual property in nearly all commercial agreements. As you may know, intellectual property is owned by the person who creates it, and there are exceptions for employees where it's owned by the employer. But so in nearly all the sort of agreements we're thinking about, things like distribution agreements, manufacturing agreements, consultancy agreements, IP will be created and you need to think about who will own it.
As a customer, do you always need to own the intellectual property?
I think you need to think about whether you should own it. Obviously, ownership gives certain advantages, but you don't necessarily have to own it. And as the person who commissions some intellectual property to be created, you will have an implied license. But there can be problems with the scope of that license, and it can create uncertainty. So just for an example, if you've asked someone to create a logo for you for your headed note paper, then you might want to use it to put on a product. And then the question is, does your implied license extend to the use on the product? And perhaps more importantly, there are issues about the exclusivity of such an implied license. So if it's being created for you, can the person who created it use it for one of your competitors? So if you're going down the license route rather than owning it, then I think you need to be more express in your agreement about the sort of license you've got. Is it exclusive? It certainly should be royalty free. Should it be worldwide? Is that for all countries where you might want to use the IP, and you might want to set out the purposes for which you can use it?
How about joint ownership of intellectual property? Does that cause problems?
Joint ownership of IP is one of those issues that people tend to steer clear of. I think the main reason why it can cause problems is that the rights that each joint owner has differs between different countries and different intellectual property rights. An example of that may be patents. For example, a joint owner of a patent in the US can exploit that patent, but also can license and assign it as if it was the single co-owner. Whereas in the UK, that you can exploit the patent, but you can't license or assign it. And for copyright, you need the consent of both co-owners to do anything at all. So it can cause a problem if you leave it just up to the law. So what you should do, and it would not cause a problem if you just say explicitly in your agreement what rights each co-owner has.
What provisions in commercial agreements can cause problems in transferring IP?
When you're transferring intellectual property rights, you need to think about how you're actually going to do that. What are the operative clauses in your agreement? I think the best sort of clause is to say that the intellectual property on creation vests in the other party. And that is a solution that deals with all intellectual property rights, all types of intellectual property. You sometimes see agreements which says that the supplier hereby assigns intellectual property, and that works very well for future intellectual property if it's copyright, but it doesn't work at all in relation to inventions, and therefore this vesting on creation solution is one that I think works for all IP, and that's the sort of route you should go down.
How do you deal with the risk of infringing third-party IP?
Well, the risk of third-party infringement is one of those elephants in the room. It's a real big issue that people are worried about. One of the reasons they're worried about it is actually the liability that can be incurred, particularly if you're thinking about infringement of third-party IP in America, where damages and costs can run to millions and millions of dollars. The way you deal with this in many agreements is by warranties and also by indemnities. If you're thinking about corporate agreements and licenses, then you usually don't get an indemnity, you get a warranty, and very often that's limited to awareness. It's not a complete transfer of risk. I think the difference in commercial agreements is that you're buying a service or you're buying products, and as a customer you want to buy that free of such a risk. So in which case the risk is transferred to the supplier, and that's usually done by an indemnity. But if you're a supplier and you're giving such an indemnity, you need to think about what is the cost of that to me and how can I limit that cost and then be reasonable. And things you need to think about are, should you be indemnifying for modifications that are created by the customer, or combinations of what the customer puts with your product? What about the territory? You happy to provide indemnity for the whole of the world? And what about different areas of use? So these are the things that you need to think about in terms of limiting indemnity to be reasonable and practical, but not open yourself up to too much liability.
So Luke, what are the most important factors for in-house lawyers to consider when addressing intellectual property and commercial agreements?
I think the factors you need to think about are, firstly, just think about IP. IP is relevant to all commercial agreements. The second point is, if you're transferring IP, make sure that's done effectively. You have an effective operative clause. The next point is you might not need to own the IP, and that might be a conscious decision, but if you're getting a license, you need to think about setting out expressly in the agreement what sort of license you're getting. And finally, you need to think about the way that you deal with third-party intellectual property infringement, whether it's by way of a warranty or an indemnity.
Luke, that's a really useful overview of changes in intellectual property law and how they impact commercial contracts. Thank you.
Thank you, David.